I have this thing, and I call it the birthday card, screw you card syndrome. And it looks something like this, and it happens weekly in my practice. My client and I will sit down and we're trying to settle. And we say, we need to send the other side a no kidding birthday card. So let's see. Let's put some alimony on it. Let's put some cash on it. Let's put a percentage ownership in the business in it. Let's put something in here for her mom. Let's put something in here for the doggy. I mean, we're putting glitter and color in this birthday card and heart, everything we can do to make it a nice birthday card. And we're trying to say, we're sorry, we want to take care of you. It's not even your birthday yet. Happy birthday. And then I've been on the other side of that table. And I get this card and I go, well, looky there, it's a birthday card. And I'm showing it to my client. I said, can you believe, look at this birthday card. And she opens it up, and what she reads is, this is a screw you card. I don't care a thing about you or anything that you want. It's a screw you card. And I'm going, no, it's not. Look, see, here's the sprinkles, here's the flower. Can't you see the glitter? Look at that. And they can't see it. And it's because of who sent the card. And so here again, with that financial neutral in there sometimes, they can develop a birthday card for both people, that because of who the sender is, it can be seen as a birthday card. Or even if it's not seen as a birthday card, it's not seen or interpreted as a screw you card. And man, that happens every day. And people can't help it, I mean, you see what you see with the eyes that you're seeing it with. And, that we say in the collaborative process, we try to, and this is a whole different thing, fair is not a great word to use when you're trying to resolve a dispute in the collaborative or any other process, really. Because when you're talking about fair, it depends on who you are. If you're the chicken or you're the fox, as to what fair looks like. The fox is hungry, looks like it's fair to eat the chicken. I'm hungry. If you're the chicken, it looks like it's just fair as it can be to run away and get away from the fox, and he don't get nothing. So it depends on who, and that's humanity right there. And so getting in a process where you focus on, it's going to have to be acceptable. It's going to be something that'll work. Something that sometimes is less worse than some of your other alternatives. And in some of these collaborative cases, we like to talk about win-wins and these beautiful solutions. And the great thing about collaborative is where those are possibilities, they come true. There are win-win results out of that process. But they're not in every case. And I don't know what the percentages are. In my cases, those win-wins, I don't know, maybe a third of the time, maybe 40% of the time, I don't know. A lot more than whatever you're going to get in the courthouse, by far, no question. But a lot of times it's just they're difficult cases, and what people are choosing is, well, this is less. I've got two options. I don't really like either one of them, but are they less worse than my alternatives? And you know what? Less worse is good. When they say it's going to cost you an arm and a leg, if you can get away with just an arm, I'll take it. I don't like it, but I'll take it. And sometimes, that's the best that you can do, less worse. But less worse is less worse. And sometimes when you're comparing to the litigation process and your potential outcomes and your costs, less worse is a lot. The difference can be a lot. it is about results for me. And so when I sit down and somebody comes in and they say, here's my story, one thing that collaborative has taught me to do is ask, well, tell me what your goals are, tell me what your interests are, tell me what your concerns are, and then tell me some more about why that is. And that's now a priority, in my client interview. And it used to, be a whole bunch of other stuff, but that's where I start now. And now at my toolkit, I've got kitchen table, I've got collaborative law, I've got litigation with maybe the goal of going to mediation versus trial, and then I've got, no, this one needs to go to the courthouse. And so when they come in with their issues and their problems and their goals and all that sort of thing, I'm just listening. And then I say, well, where for that client's own selfish self-interest, where are they best suited? And some of them, and this frequency is, well, it depends. A lot of them don't need any process. You need to go home, sit at the kitchen table, and get this sorted out. That's some of them. Some of them, the better deal is at the kitchen table. Go get it. That's the kitchen table for many people is all you need, because there's not much to fuss over, or they're already in agreement. But it's a high risk environment, and the high risk comes from there is the chance that somebody's going to run away from there with an absolutely outstanding deal or just a terrible deal. And the risk is you don't either know enough about the facts or have enough financial information to make an informed decision, or you don't have enough information about the law. But if you're the one with the superior knowledge on both of those things, sometimes a kitchen table is the place to be. If the weaker party comes to see me, I'm not going to be advising them to go to the kitchen table. We'll pick something over here. Collaborative law, for most couples, and for most of my, forget the couples, for most of my clients, that's where their interests have the best chance of being best protected. That's where they have the best chance of getting the results that they've told me are important to them, just because of what they say. But there are some people that, based on what either their factual situation is or what they've told me their goals and interests are, so none of these things are going to work for you. You need to line this one up to go to the courthouse. And here's what that's going to look like, But based on what your goal is, this is the only place you've got to even do that. So it's, for me, to be a full service lawyer today is, if you're going to try to help all comers, you've got to have a skill set that can encompass all of those options. And so it's harder. There are some people that are born to be trial lawyers somehow. And you know what? This debate, collaborative litigation, which is better, which is worse, for me, it's like arguing about which wing of the airplane is more important. All right? The damn thing won't fly unless you got two wings. And our justice system has got to have a way to go to court. You've got to have it in this society, or we just can't do the way we do things here in America without that. At the same time, there are lots of families, there's lots of businesses, there's lots of people with disputes who don't want to go to the courthouse to resolve those. They want something else. And collaborative, restorative, mediation, all those alternative dispute resolution processes are that other wing, and we've got to have both.